Name of the Father, the Son, the Holy Ghost. Amen. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus.
Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen.
Name of the Father, the Son, the Holy Ghost. Amen. Brethren in Christ, Laudetur Jesus Christus in Sequela. This is Timothy Flanders with the meaning of Catholic. Today is Ember Friday. It's also SCOTUS Eve. Tomorrow, the long anticipated, for a week now, appointment of Trump's nominee to the Supreme Court, expected currently to be Amy Barrett, according to the reports coming out in the past few hours. Here with some legal analysis is Gordon and Gordon. Dave, Tim, how you doing?
Yo, how are you?
How's it going, Timothy?
Here.
Thank you for having us.
If you don't know, both Timothy and Dave both have law degrees. And so we're going to have a little bit of legal analysis, a little bit of historical discussion to give some context for the appointment tomorrow. Before we get into that, the Marxist YouTube bots have already zeroed in on this because it has the word Supreme Court on it. So your job, viewer, is to share this video, please, against all the Marxist bots coming after us. So that'll help us spread the apostolate. A couple announcements as well. Next week, we have a very special debate, Vatican II. Does Vatican II break with tradition? It's a debate between Matt Gaspers of Catholic Family News and Chris Plants of Retrograde fame. So don't want to miss that. It's going to be really great. I think we'll get into a lot of important controversial issues that have been discussed recently, as well as in a couple of weeks, we have new release from Kennedy Hall, Our Lady of Victory Press. This is a novel about the lockdown. It's a novel that takes place in 2020 at the lockdown about two demons trying to damn a family of four. So you don't want to miss that. It's a great, great book. I think it'll help a lot of people, and we'll laugh and cry together about it. So without further ado, let's get into this topic. So the topic is the Supreme Court. I want to start with a quote from Rules for Retrogrades, the book that both of y'all wrote. Page 7, you say this: the framers of the U.S. Constitution, like James Madison, recognized that natural rights in republics were best secured by localism, a principle derived from the Catholic concept of subsidiarity. Madison and the framers called the concept federalism, not subsidiarity, although it proves to be a simple Reformation, Enlightenment, reproduction thereof. So we have this concept of federalism that you discuss in the book. Tim, I'm wondering, can you tell us, do you think that federalism is the loss of federalism the essence of the decline of the republic?
Certainly, from a structural governmental point of view, yes. From a cultural point of view, no. And I mean, that's what a republic is the under substratum of the culture and the over ether, if you will, of the political structure. It's the decline of the political structure which expedites the decline of the culture. In other words, you get lots of folks taking a stab at what they want subsidiarity to be. But if you look at Pius XI's definition of it in Quadragesimo Anno, he makes it really clear. It is localism and on a structural basis, meaning in America, when you have imperium in imperio, which is a concept that comes from Magna Carta, we have literally an empire within an empire, two governmental structures. What we're going to be talking about tonight, Tim and Dave, is the two empires within American government, the great American experiment. The federal governments actually originally meant the state governments, the several state governments, three branches there, and the national government, which we now call the federal government in a weird twist of fate, which is that those same three branches overlaid at the national level. And how it's supposed to work, subsidiarity, is that the state's supposed to have the several state legislatures, several state judiciaries and executives are supposed to have more power than the national. And it got inverted, and we're going to be talking about how it did so tonight.
So does the state legislature body, is that supposed to guard the culture of that local region? Is that what you're saying, with having more power of the...
Of course. The 10th Amendment describes a police power for the state. This is all really clear when we go back to the original founding. The 10th Amendment describes something called the police power of the state. That is the ability of state legislature to govern the health, safety, welfare, and moral security, of their people. So the moral legislation is supposed to come from the state or as a subsidiary of the state, the municipal government, not the federal legislature, the Congress. That's because that's more far away, it's more remote. So all it's supposed to do is outlaid in Article 1, Section 8, 16 really mechanical, boring things like coining money. None of the nature of health, safety, welfare, morals, none of the nature of those things pertain to the federal government unless, which is what we're talking about tonight, there's a bastardization and a purloining of those functions by the over government, the central federal government, from the several state legislatures, which is what we're going to be talking about.
Okay. So, and Dave, can you tell us what is the function of the Supreme Court in that setup? What is it supposed to be in your mind?
Sure. Yeah. Well, the Supreme Court's there to be the highest law of the land, or the judiciary is to say what the law of the land is. It's to interpret the Constitution and to interpret federal legislation. Obviously, with any legislative body, you also have to have a branch of the government that's dedicated to saying what law is, and when there is a dispute of law, who is in the right and who is in the wrong, or who is in the wrong. And there has to be somebody there who is going to apply the law to the facts and say how the law intersects with a given set of facts. Now, the problem is, especially in a system with stare decisis, where you have one case that makes precedent, what's called legal precedent, and that binds courts farther down the line. It binds the Supreme Court further on in time, as you get this chronological development of the court and the continuity there, even through the court with various justices on it and various iterations of the court. Obviously, the institution prevails, but it's a body that's headed by 9 additional justices after the previous justices die or retire. Now, the idea of stare decisis is really that the court's not going to be arbitrarily reversing itself every 5 years to lend stability to the American essentially legislation and constitution, because if you have the law and the interpretation of the law changing every 5 or 10 years, then you're not going to have a very stable system. But it also binds the lower courts. So stare decisis, under the Supreme Court, there are the federal trial courts, the district courts, and the courts of appeals, and they're bound by the court's decisions as well. And this stare decisis, when you get cases originally perverting the federalist system, the states' rights and the 10th Amendment, and how they intersect with the federal government and those powers that are laid out and given to the federal government in the Constitution, you have a big problem. Because what we saw early in the Republic is that things like the necessary and proper clause were, as Tim said, bastardized to basically make a whole new system that's extra constitutional. So if you give Congress a certain amount of power in the Constitution, it has certain duties that are delegated to it, then that's good, because that was meant to constrain their powers. It was meant to confine their powers to what is located on this document, because the framers, the founding fathers, were all afraid of a huge central government, which is why they took this system. They devised this system of states' rights and states' powers and police powers inhering in the states, was to be a hedge against this all-encompassing mammoth federal government, which we had just seen kind of in the English system. So, but right away with jurisprudence, that got bastardized because the courts said that whatever is necessary and proper, there's the necessary proper clause of the Constitution. The courts interpreted the necessary and proper clause of the Constitution to say that the federal government can take whatever action basically is convenient and supplies its delegated duties, whatever is essentially convenient for it to accomplish its delegated duties, it can do under the necessary and proper clause. So now you have this scope of congressional powers, of legislative powers at the federal level, just greatly expanded, because as long as you can connect a piece of legislation or an initiative of Congress to one of the explicitly delegated duties of Congress, then you can say that this thing is in the Constitution, this power is in the Constitution, and you can really ramrod it in. So that gave us a foundation for the destruction of federalism right at the outset of the Republic.
Okay, so you're saying that the Supreme Court used certain clauses in the Constitution that you're saying were designed to limit the federal government for the sake of the state, local custom, local culture. But the Supreme Court gave to itself these powers using an interpretation of the Constitution.
In Congress, those powers. Now, the Supreme Court also, now this is debatable because it's talked about in Federalist 76, but judicial review, the Supreme Court has arguably given itself some powers at some point, but even early on with...
Is this Marbury versus Madison, 1803? Is that
right? Exactly. Marbury versus Madison.
78. But, yeah.
Sure. Just the basic point is that the Supreme Court has kind of aided in the expansion of federal power by giving Congress, especially through necessary and proper clause, tax and spend, and later on through the 14th Amendment, Congress has increased and growing legislative authority.
Okay, so it's the destruction of federalism, the suppression of the local governments is already happening within the generation of the framers of the Constitution.
Yeah, and that's something I think Tim talks about quite a bit, is this federalist, anti-federalist split. It's really hard to have a national identity when you have two parties that are far away from each other in terms of worldview and understanding of human governance and power as you had in even the anti-federalists and the federalists. And that really has metastasized. The distance has really metastasized between the two parties and the two-party system. But we had it right at the beginning of the Republic, and it's never gone away. And there's just this huge tension in the Republic itself because of the nature of that anti-federalist federalist split.
Yeah, and just for non-American viewers, just to point out, there was an original Constitution called the Articles of Confederation, which was much more decentralized, much less of a federal government. The states were basically independent nations, and then that was transposed. That was thrown out totally. The Constitution was written, giving a lot more power to the federal government. That's what we're talking about.
The Articles were one branch government. There's just a central Congress. Congress is a treaty gov term, so it's the term federal. It's treaty government, which is like the United Nations getting together in wartime and teaming up. And the 13 states were 13 sovereigns that were basically just under the Articles of Confederation working together. What's the really important point that people that haven't studied the Constitution much ought to bear at the front of their mind is it's great in the conservative academies and the conservative liberal arts colleges in the United States, like Hillsdale or University of Dallas or Claremont or whatever, that they study and they brag about studying the Federalist Papers, written mainly by Hamilton and Madison. But the problem is the Federalist Papers are one half of a dialogue. The Federalist Papers were arguments, or they were decent arguments. Dave was mentioning the argument for judicial review in 78. The other important ones are 10, 39, 51. They're numbered.
Is it 78? I think I said 76. I was getting mixed up.
Yeah, no, it's. I mean, all the 70s are about the judiciary, but those are the big numbers. But there were rejoinders by anti-federalists, important guys like George Mason, George Clinton of New York, even James Monroe was writing. The Lee brothers were writing responses. And when we look back with the luxury of history, and the anti-federalist responses, particularly the pseudonym of a guy named Brutus, his first, second, fifth, sixth letters, another one named Cato, another pseudonym, his fourth letter, they pinpoint precisely the parts of this proposed new constitution with more energetic central government, where the Schwerpunkt will be, where the weak spots will be, where the federal creep will happen. And particularly Brutus. I direct my students to go read Brutus's first, second, fifth, and sixth letters. He hits the nail on the head in terms of the Article 1, where the Congress would grow its power, and Article 3, where the judiciary would grow its power, and how they colluded to grow one another's powers. The three branches are supposed to be rivalrous. Instead, Congress and the judiciary really worked together to aggrandize one another, and they did it in the precise points in the Constitution. Dave mentioned one of them, But there were other ones that Brutus was even more concerned about, to grow the national three branches over the state legislatures and the state judiciaries. That's what's really, really important. And they were all concerned about the presidency too. That seems to be the branch that's been the least abused, ironically, was the one they were most concerned about. But it was really the collusion of the national judiciary, the High Court SCOTUS, and the national legislature, we call it our bicameral Congress, against the federal or the several state legislatures and judiciaries. And that's what we're talking about when we start to talk about all these cases that you were texting me and Dave about.
Right. Yeah. So we're going to get into that. So one objection might come and say, well, why can't we just side with the Federalists? Because states' rights and local custom have been on the wrong side of two very important moral issues. One is slavery and the other one is racial segregation, both connected, obviously, by 100 years between the 1860s and the 1960s. And so could not one argue from the Federalist side and say, well, local customs are nice, but there comes a time when the federal government has to expand itself for the sake of the common good. Dave, go ahead.
Yeah, it's a bad argument because just mathematics. And what I mean by mathematics is that, okay, so say there's a 50% chance of living in a state that's got something wrong. Over the course of time, because power tends to corrupt and absolute power corrupts absolutely, there's a 100% chance that if you have a top-down government, this singular federal behemoth, you will end up living in a tyranny. The states were a protection, a hedge against tyranny, in that you have 50 independent labs of experimentation. And this is where you have to think also, and I think this is one of the places where the Founding Fathers got it wrong, actually, is their trust in the political process. The Founding Fathers all believed that if things were going wrong in a state, then people would either move states, or through their political process, they would be, attuned enough to what was happening politically in their state and locality that they would vote out the bad and corrupt and foolish politicians. Now, that's proven to be false in a lot of respects. People are loath to use the federalist system. I mean, I can't believe anybody still lives in California in the United States, or someplace like Connecticut. That's crazy. Why haven't you moved yet? You live in like these dystopian states. They're bad places. All the Founding Fathers thought you would have recourse to these, to your right to move, your right to transfer localities if your state was like irreparably broken. But the other thing is, before it got irreparably broken, the Founding Fathers believed that people would be more engaged in the political process. Now, this was, of course, partly they aren't to be blamed for this because they believed in a more aristocratic voter, one who was going to be, the voting class was going to be limited to people who were erudite, well-educated, and had a stake in the game. They didn't think it was going to be a bunch of inner city folk who depend on welfare for the livelihood. So it's partly gotten out of hand. But nevertheless, even with those current limitations on the federalist system, where states are, the political process isn't working out the way it was envisaged, and that also people are not taking advantage of their right to relocate to less dystopian states at the rate I would like to see. Now, obviously, there is an influx into Texas. There is an influx into Florida from New York, and Texas from California, but not at the rate I would expect. But even granted that, so say there's a state that gets it very, very wrong, then that doesn't affect the entire country. The mistakes, the errors of that state are limited to that state. So you don't like California, that's limited to California. That's fine. And those voters ultimately, are reaping what they sow. So we can say, obviously, when people vote poorly, it affects all of us in America, right? Which is unfair. So if we get Joe Biden in 2020, at least you can say, well, America is going to reap what it sowed. It's going to reap that poisonous harvest of chaff that it sowed. But, well, anyway, I kind of.
That goes right in there. I'll give it to you, Tim. It goes right into the question about Dred Scott, because Dred Scott was a slave who got his freedom, and then he lost that freedom because the Dred Scott versus Hanford decision, 1857, stated that the Constitution said that it did not intend citizenship to blacks. And so he couldn't really move out of the system because the Supreme Court came in and clamped down on him. But Tim, go ahead.
Yeah, I'll address Dred Scott in 30 seconds. But one way to rehabilitate the understanding of the original Constitution, the antebellum understanding before everything got destroyed after the Civil War, all of our jurisprudential structures, is to say that when American federalism, that is to say subsidiarity, effectually is firing on all four cylinders, the several states, however many there are, 13 or 15 or 50, they are restricted to their domain, and they're the ones, the 50 state, really the legislatures is where the law is made. So we think of it as the foremost of the branches. They are, as Dave said, the fora of experimentation, as the late great Nino Scalia called them, and they can do whatever they want. The moral cost is they're going to be doing different things. And to some extent, it's never really stated by the founding fathers, but there's an implication and insinuation that you can migrate around, which is what Dave's talking about. When the central government's supposed to really only do things like effectuation of war, implementation of taxes, coining money, other aspects of the Comity Clause that mean that we'll have the basic infrastructural same rights if we do travel from state to state. But the idea of the original Constitution, even as it was more energetic and arguably too energetic compared against the Articles of Confederation, was that when things functioned as they were supposed to up until the Civil War, yeah, you're going to get certain states doing things as a function of their legislature that other states might object to. And so states' rights, state sovereignty, federalism working out properly stands for slavery no more than the current American flag and the current system of perverted, upside down, lopsided American federalism stands for abortion. You know, I mean, you have grave moral evil once you have a system of lopsided federalism, which we've had pretty much since the North won the Civil War and we got the 14th Amendment, aka the new Constitution. It took over everything. Now it just guarantees that when you get the mechanisms of the 14th Amendment, which are evil and might be punishment for slavery, who knows, they will be enforced at the national level. So instead of having one little state making the murder of fetuses legal, now we have a government that comes like an overlord and ensures that it will be nationally guaranteed that it's illegal for the 50 state legislatures to make it illegal to kill an infant.
Same gay marriage. In gay marriage, Tim, we got national gay marriage under the 14th Amendment because of the danger of destroying. Well, yeah.
Everything's under the 14th.
Well, let me, Tim, can you break down for the viewers what is it about the 14th Amendment? Can you give us a historical context of the 14th Amendment and what exactly is it in the 14th Amendment that changed everything?
Sure. So the 14th Amendment, if you get out your pocket Constitution and you go there, it's written like a second Constitution. It's got this privileges and immunities clause, which were almost immediately read out by a series of cases called the Slaughterhouse cases. This was really the direct response, by the way, to Dred Scott, that blacks were supposed to have privileges and immunities, and they got read out for a complex, barely related reason in the 1890s called the Slaughterhouse cases. But it's got a second due process clause, and this is the biggie. And it's got an equal protection clause. And all of these are long. It's not written like the other amendments. It's the second Constitution. So I would say there are three major things wrong with the 14th Amendment that allow it to bypass all of the processes of the real Constitution, meaning Articles 1, 2, and 3 of the Constitution, where the Congress makes law, the executive enforces law, and the judiciary, in a restrained, restricted way, interprets law according to the higher text. That works. What doesn't work is about the 14th Amendment. We have a new due process clause. Most people don't know that the Bill of Rights, the first 8 rights, the first 8 amendments in the Constitution, enumerate rights that are inviolable by people. If you leave a blank there, people will say all government. That's not right. until the 14th Amendment was passed, there was one of our two layers of government that could not violate our rights in the first 8 amendments, the Bill of Rights. It was supposed to just be the federal government. You get this when you read Amendment 1, Congress shall make no law respecting an establishment of religion. Well, the second due process clause, or some people say it was the equal protection clause itself, threw into sharp relief the balance of powers, because now it allowed, and you'll see why when you consider what slavery was, it allowed in this second due process clause, not the Fifth Amendment due process clause, but the 14th Amendment due process clause, the basically states were not allowed to violate, as a function of the police power, the rights of individuals. This is called incorporation. So the Bill of Rights were incorporated against the states now as well. This threw the balance of powers way off. That's one thing that's really wrong, particularly through something called substantive due process, which now it actually existed arguably in Chief Justice Taney's opinion in Dred Scott. Some legal scholars cite that substantive due process comes from his decision. And there's an irony there, because from his decision, you get the 14th Amendment, which makes large and muscular the idea of substantive due process. From substantive due process, you get the idea later, it takes about 100 years to develop, in Griswold versus Connecticut, of the right. All these fake rights come from substantive due process. So the right of, I should say this, the right to contracept and to purchase contraception in Griswold v. Connecticut, substantive due process. The fake right to pornography in Stanley v. Georgia in 1969, the fake right for homosexual acts, substantive due process in Lawrence v. Texas in 2003, the fake right of gay marriage in Obergefell v. Hodges in whatever that is, 2015. All of these fake rights that the new Constitution after the 14th Amendment seems to grow, just spawn like a factory, come from this made up notion of substantive due process, which comes from the second due process clause, which allegedly constrains the states as well as the Fed. The reason they needed to do this was because now the federal government was in the business of telling the state legislatures what to do. It wasn't doing that before. All of the important legislating powers were supposed to come from the state legislatures, come what may. They're the fore of experimentation. So we just had now we have a lopsided sense of who's got the final moral authority. Now it's no longer the 50 states where you can go to another state if you don't like it. Local customs aren't being observed. Now we just have abortion, and abortion is a function of substantive due process. All of these wicked things come from the 14th Amendment.
Okay,
which came from the Civil War.
Okay, so the substantive due process is basically inverting the right of the state powers to regulate their own affairs and arrogating it to the federal powers to then impose what they believe is correct onto the states. One of the
more or less. It's complicated, but okay. Yeah. We're trying to
I want to ask you one more question about the 19th century. I want to get into the 20th century, which you mentioned. Tim, you've brought up before in your book, Catholic Republic, about the 9 state churches of the nine of the 13 colonies, which is the argument against that the American founding was a purely secular Masonic invention. And I'm wondering if the 14th Amendment was really sort of the shift towards the suppression of the local customs. Were the state churches still thriving by 1860s? I mean, was this still going on in these 9 original states? Do you know the history there?
No, not in all. It was 8. 8 of the original 13 had established sects of religion, a state establishment of religion. They were all different sects of Protestantism. No, they weren't, but a few of them were. But here's the good part. If, whatever, let's say half of those 8 states that had a state established religion deign to abolish their state establishment, then that's fine, because that's coming from the local area. It's not coming from the center. I mean, we think it's a good idea, right? None of them will happen to be Catholic establishments of religion, as it happens. But the point is that they were coming from the state. Now, so this is a function of incorporation, which also comes from Some scholars say the due process clause in the 14th. Others say it comes from the equal protection clause in the 14th. Justice Thomas in Heller, the case which incorporated the Second Amendment, which would otherwise be a bad thing, but we might as well have it since we have the evils of incorporation as well. We might as well have guaranteed gun rights.
Tim Heller,
he said it came from the Privileges and Immunities Clause. But here's the answer to your question. It's that because in the antebellum United States of America, the first 8 amendments, including that First Amendment with the 2 religion clauses, the Establishment Clause and the Free Exercise Clause, because that specifically delimits the federal government and only the federal government from establishing a state religion, it specifically allowed all of the state legislatures to establish a state religion, or in less robust cases, to restrict your gun rights, or to restrict your crim pro rights from the 4th, 5th, and 6th Amendments. State legislatures could do that until the 14th Amendment. Then with the 14th Amendment comes this thing called incorporation doctrine, where it's argued now these proscriptions on government power will be incorporated against the state governments as well. And so that's what destroys forever the ability of states at that point in 1868, when the 14th Amendment was passed, individual state legislatures to come up with an established state religion, or to regulate in any meaningful way any field of legislation being legislated by those first 8 amendments. It's really important, and it's a radical reshifting of the balance of power.
Yeah, this is very important. So let's get into the 20th century with this context, because what I see historically is that when the elites start to impose pornography on the United States in the 1920s sexual revolution with Hollywood, the conscience of America, the local custom, I mean, there's just a strong religious culture, Protestant, Catholic, Jewish. There's a strong religious culture still present in this time, which causes a reaction, which provokes the Legion of Decency from the 1930s to the 1960s. And ultimately, the Catholics are the ones who lead the charge against this obscenity, this filth in Hollywood. And it seems to be that, like you're saying, Tim, the elites are able to use the courts ultimately to take a minority, some minority who's has some beef with the state law somewhere, and he's able to bring it up to the Supreme Court. He wants to have his pornography in his smut book or whatever. He makes it to the Supreme Court. The Supreme Court then rules in his favor and imposes that on all the states who are unwilling to do this in the first place. So, Dave, let me ask you, is the 20th century, I mean, I've got, there's a link in the show notes. I just put out some of these notable cases. So you have 57, 62, Roth versus United States, Engel versus Vitale, against legalizing pornography, state school prayer. You have Griswold versus Connecticut, contraception. Then we lead straight into Roe versus Wade. And then later you talked about gay marriage. It seems that in most of these cases, there were already state laws on the books that these were striking down. So, Dave, is the Supreme Court becoming in the 20th century sort of the tool of the elites to impose their will on the masses? Yeah,
and this is exactly why this election is so important, and last election was so important, because the Supreme Court, because of the supremacy clause of the Constitution, which says that the Constitution is the supreme law of the land, and since the Supreme Court, due to Marbury versus Madison, is truly the sole arbiter of what's in the Constitution, it's basically an unchecked, indirectly checked power. It's checked in this indirect way by the legislature, which the Senate, which confirms the justices, and the president, who nominates the justices. But once it's spoken, it's basically unchecked. It's become the tool by which you can basically get super legislation passed. Legislation at the judicial level, when you're talking about what the Constitution means, you can get that passed and it will bind the country forever, for generations, until you get the court to reverse itself. That's the only way, or a constitutional amendment. Constitutional amendments are exceedingly rare, as we all know. And the court reversing itself also because of their blind allegiance to this silly notion of stare decisis, which is basically, again, the court adhering to its past decisions. So if it gets one thing wrong in a past decision, then it's going to get that thing wrong in future decisions. And it's going to slowly fall victim to entropy, because it's like making a copy of a copy of a copy, and you're getting less and less clear as you get away from this one wrong decision, which is now redounding to our eternal shame in terms of our jurisprudence. So that being the case, because the Supreme Court is this super legislature, it has become really the weapon of choice for the left to get across its policy agendas, which are unpopular. And the Supreme Court was politicized chiefly. Who do we have to blame for this? It was FDR, Roosevelt. When the Supreme Court was originally striking down most of Roosevelt's favorite legislation that was supposed to help us bounce back from the Great Depression, right? The New Deal and the National Recovery Act. And the court kept giving him unfavorable to him decisions that were enforcing the Constitution, despite the legislatures and the presidencies overreach in their attempts to usher in this era of big government. I mean, FDR is, by true metrics of what is good governance, was the worst president we've ever had. He was a disaster for the country. So what he did when the court kept striking down his favored policies was he said, I'm going to then pack the courts. What you hear the Democrats actually saying right now in the wake of Justice Ginsburg's death and the fact that Trump is going to get a third judicial nominee and probably a third appointment on the Supreme Court during his first term of his presidency, you hear the Democrats talking about, well, we're going to expand the number of justices on the court, which is going to give the next president, basically the next Democrat president, an ability to fill these additional seats on the Supreme Court and make the Supreme Court to his liking, because the number of seats on the Supreme Court, the number of justices on the Supreme Court, is actually not something that is written into our Constitution. It's something that's set legislatively. So what FDR did was he threatened to pack the courts, and they call this the switch in time that killed, or that saved 9, because when he threatened to pack the courts, the justices, a couple of the swinger justices, not the swingier justices, the ones that were more politically moderate, actually started voting with him in favor of the New Deal and a lot of the legislation that he was pushing through, which is on its face basically an unconstitutional power grab by Congress. You know, you have the famous case of after the court packing plan and after the switch in time that saved the 9 justices, you have basically the court upholding that you can regulate if somebody grows crops in their own backyard. So it's truly an expansion of the federal government at the expense of states' rights, individual rights, all that stuff. And that really was one of the main things that politicized the courts. You can look back at like John Marshall in the early part of the Republic in the Marshall Court. Of course, he was a Federalist nominee, and that really set the trajectory of the nation, because at the beginning of a nation, when you're interpreting these fundamental parts of the Constitution, if you get some victories in the favor of one ideology, i.e. Federalists over anti-Federalists, then that is going to have really ramifications that ripple through the rest of the Republic. So when you get these major victories, like saying that the necessary and proper clause really means whatever is expedient for Congress to go through with its enumerated powers, but it didn't really mean the words only necessary and proper, that's going to affect the rest of the Republic as we go on. It's like in Monopoly, if you get behind on the first couple dice rolls, you're kind of behind for the rest of the game. It's really hard to catch up unless you roll like doubles a few times. And that's what happened. Since the Federalists kind of had the reins of power at the beginning when our case law and our national identity was being formed, we got some errors in our jurisprudence that have had poisonous ripple effects 200 years later. But since the Marshall Court, probably the most important court was the court that was really swayed by FDR, and that set the stage for a huge expansion of judicial power, and this poisonous judicial philosophy of really looking beyond the words of the Constitution. So you can't have the Warren Court, which is responsible for much of the mischief that was ushered in the the 60s, and many of the progressive policies that were ushered in the 60s, especially vis-a-vis pornography and what you're referencing right now, without this change of judicial philosophy that took place because of Roosevelt and his court packing.
Excellent. It's very interesting. I know, Tim, you have mentioned, I believe, that this was when there were a few Masons on the court. Is that correct? During this period?
Yeah, there are 7 of 9 Masons on the court in the 40s and 8 of 9 in the 50s. It was really after World War II that things changed around drastically and paved the way for the 60s a generation later. But one point I always make to traditionalists who are new to jurisprudence, new to constitutions, new to reasoning constitutionally, is that it was not until 1946, a case called Everson versus Board of Ed, where the official meaning, as recognized by the court of the High Court of the Land, was reversed. That the First Amendment was taken to mean a strong wall of separation between church and state. It had never been a strong wall of separation between church and state, and the smoking gun proof is the idea that after the Bill of Rights was passed in 3 years after the Constitution was ratified in 1791, it stood for the proposition that 8 of the 13 states would have little Protestant integral nations with state establishments of Protestantism, which they did until the 14th Amendment. So I just want people to understand this. Even after the 14th Amendment was ratified in 1868, it still took those 7 decades until the court was in the position to do what they wanted to do, and it was a Masonic goal. But my point in saying this is it was an official reverse. If you go read that 1946 position where they're saying the First Amendment used to stand for the idea that state governments can establish religion, just the national government can't. Now we, the 7 out of 9 Masons who are on the High Court, are saying that state governments can't do this, and we're interpreting using the same jurisprudential mechanism, the First Amendment, then something has happened. You've reversed the meaning of the original Constitution and the original First Amendment. That proves the case that it was once good, it was perverted by Masons, it was once anti-Masonic, as the Bill of Rights was ratified in 1791, and it became Masonic through the reversal. It's a smoking gun, and people who are accustomed or who favor the worldview, which stands for the proposition that the United States Constitution is founded in 1788 and as amended 10 times in the Bill of Rights, was originally Masonic. It's just nonsense. It's nonsense. And the proof is the fact that it had to be reversed in the 1940s after World War II.
Go ahead, Dave.
I've got to add this. Yeah, with substantive due process, and this is where you get like this idea, when we get incorporation into the 14th Amendment. Let's talk first about incorporation. It's really dangerous when you start talking about federalizing things that pertain to the states. Tim, what was the case earlier that you mentioned?
Heller is when we federalized the Second Amendment.
That was McDonald, by the way. Heller was the DC.
It was McDonald.
Yeah,
Heller couldn't do it because it was Washington, D.C. So it wouldn't have stood for the proposition that the 14th Amendment, which constrains its due process clause, constrains the states. It wouldn't have stood for the proposition of undoing the Fifth Amendment.
Okay. Under this substantive due process test, though, one of the main things, and this is a fatal flaw in the Roe court's logic and Roe v. Wade court's logic, is that there had to have been this right that was essentially recognized as inviolable from the beginning of the Republic, from the very outset. And Roe, essentially, if you look kind of a layer deep, applied this to abortion, which is why they spent so much time talking in the Roe v. Wade opinion about abortion was illegal in most of the states for most of the republic. It was a criminal offense, and they had to make it that was to protect the women because they didn't have access to safe medical treatment and safe abortion procedures. So it was to protect women and not the actual baby itself. So there's this little trick, which is, and this is how you know that the statists on the court, these big government activists, judicial activists on the Supreme Court during the 40s, 50s, 60s, 70s, when they're carving out all these rights, this is how you know they're wrong. It's that from the beginning, as we've seen, there were 8 out of the 13 original states that recognized a state religion. So you can't say that this idea of substantive due process applies to separation of church and state, and it's something that we just have as kind of a right, and it was recognized at the beginning in the Constitution because 8 out of the 13 original states had a state religion. You can't take that with substantive due process and apply substantive due process because the proof is in the pudding. It wasn't a right recognized from the beginning of the Republic as inviolable, and you can know this because 8 out of the 13 states had laws on the books that recognized an official state church.
It's a slam dunk. It's a conversation ender.
Right, and that's why it was really important in Rules for Retrogrades, and I was horrified that this got stripped out. But I was citing, books written in the late 1800s that talk about it's a murderous act and that abortion is wrong because it's murderous to the baby in utero when it takes place. And I was trying to point to that and say, obviously, the Roe v. Wade court got it wrong. Here's a book from, the late 1800s talking about abortion is wrong because it's murder, not because it's unsanitary for the mother or because she doesn't have access to high-tech abortion facilities. But this substantive due process, it's very, very dangerous, and it's been weaponized against us, and it's not even being held up to its own standards because, again, even if we were to, and Tim and I have gone back and forth on this, even if I were to acknowledge that there is such a thing as substantive due process, which is oxymoronic in its actual language because process is procedural, not substantive. So when you start talking about substantive process, that seems to be a contradiction in the very nomenclature of the thing. But Tim has a pretty good defense of this institution. I'm not sold, so we go back and forth. But even if you believe in it, it has to be applied in the way that the court says it should be applied. And the court's not even upholding its own standard because it is recognizing things under this notion of substantive due process that weren't around and regarded as inviolable from the beginning of the Republic, if that makes sense.
Yeah, I would never defend it in regard to the way that it's applied 99% of the time. I just defend Lochner, which is what the liberals will always say, the Lochner era of the court, a case that's generally seen as pro-capitalism. Liberals will try to characterize Lochner and its progeny as a conservative version of substantive due process. That whether or not that's true, I just defend Lochner. But I mean, look at the map that Tim has up right now. What really concerns me is the nationalist, populist right-wingers out there that say, well, governing from the center is good. Subsidiarity is bad. This is really popular right now. The populists get things wrong. Well, look at that map. 33 of those states, I live in one, a bunch of our viewers live in one of the states where it would still be illegal. What governing from the center does is it allows the Masons and the big government leftists to storm the court and to storm Congress. And if they're governing from the center, make it illegal for those 33 conservative-ish states to make it illegal to have an abortion. Governing from the center makes it illegal for those 33 conservative-ish states to make gay marriage illegal. They make it illegal for those 33 or so conservative-ish states to make pornography, contraception, whatever, no-fault divorce illegal. So do people understand? The morons out there all say, well, all we have to do is get like an emperor or whatever, and then just make all the stuff we want illegal. That's not how it works. That's not how it works in Magna Carta or any of the republics that reduplicate Magna Carta, where we have this empire in an empire. What it's supposed to do, the constitutional structures, is allow at the very least those 33 states to not have abortion, to make it totally legal and criminalizable. And then they say, what about the 17 states where it would have been legal? Well, we can work on them. We really can work on them. And I would support a constitutional amendment that would come down from the top. But when you do things the lefty way and you try to just flip it on the leftists, it never works. Substantive due process is the tool of the lefties. It's the tool, the 14th Amendment has been the tool of great evil, foisting it upon conservatives and making it illegal for us to illegalize evil. People have to understand that.
And we should really just dedicate a second for the people who aren't like legal eagles or wonks or anything like that. When you're talking about the 5th and 14th Amendment, which respectively give due process at the federal level and at the state levels. So it's that no person will be denied life, liberty, or property without due process of law. So this idea of substantive due process and saying, well, you can't deprive somebody of this right at all, that on its face contradicts with the verbiage of the actual amendments themselves, which contemplate. They say you can't deprive these people of life, liberty, or property without this, which means if you do have the due process of law, you can deprive them of these things. So the wording itself has been read out of these amendments. I want people for a second to think about how silly it is that amendments that speak to the procedures by which you deprive somebody of life, liberty, or property, it's how silly it is that that wording has now been used to say that you cannot deprive somebody of life, liberty, or property. It's there. The 5th and 14th Amendment are concerned with procedure, and the court has used these amendments to usher in. It's a vehicle, a Trojan horse to usher in whatever policy is favored by the leftists, the nine-robed tyrants that are on the bench.
So I want to bring it up to today, talk about our current situation, giving a lot of context here. This has been a great discussion, so thank you. 1973 is Roe versus Wade. Roe versus Wade gets renewed in, what is it, 96?
92.
92.
Yeah, 92. Yeah, I believe that's the one where I think it was Kennedy who said freedom means that you define your own reality.
Yeah.
Which is the great catchphrase of the left, I think.
Yeah.
So why hasn't Roe been overturned, and what prospect do you see of it being overturned? Tim, I'll go to you first.
In terms of political capital, it hasn't been overturned because it is the golden calf to the left, and we couldn't count to 5 in 1992 when we were supposed to be able to count to 5. It means, do we have a majority of the bench? Anybody, look, the judiciary is supposed to be the non-political branch, right? That's bull feathers. It's nonsense. It's just a little democracy of aristocrats. Can you count to 5 out of 9? Specifically, historically, we couldn't count to 5 because Sandra Day O'Connor gave us a knife in the back. We couldn't count to 5 because there's a great amount of ungodly political capital on the side of murdering babies in the womb. And these people were probably, we know there's a deep state. These people were probably getting death threats and all manner of ungodly threats against their lives and their families. The left will cling to Roe versus Wade jurisprudence before anything else. There will be a revolution of a Robespierre's brand, of a leftist Jacobinist brand, if there's serious threat against the jurisprudence stood for by Roe versus Wade. So Planned Parenthood versus Casey was the case in 1992. I guess quixotic conservatives who follow the court were hoping and I guess expecting it to be overturned. I wasn't old enough to know then, but I was 11 years old. But it was a knife in the back by Sandra Day O'Connor. It's going to take 5 hardy stalwarts to undo this, particularly given all the saber rattling that the left is doing today. And I mean, the only decision, I have a great law school mentor that I still talk to. It says the only decision that's worse than Roe versus Wade from a jurisprudential point of view is 1992's Planned Parenthood versus Casey holding it up. And they're both done on the basis of substantive due process, along with all the other evil that we've talked about here tonight. It's all from the center, leftist style governance, instead of letting the 50 states make their own decisions.
Look, can you expand at all, Dave, if you can expand on how is Roe and Planned Parenthood, the 93 case, Planned Parenthood versus Casey, how is that substantive due process? Is it just because they're imposing on the states from above? Is that what you mean by that?
Yeah, sure. Let me, can I jump on?
Yeah, go ahead.
What Tim said at first, because we're really connecting dots from these themes we've had from the beginning of the show. So the opening line written by Kennedy and Sandra Day O'Connor in Planned Parenthood v. Casey, which is kind of one of those immemorialized opening lines, is that liberty finds no refuge in a jurisprudence of doubt. And what they're saying there in this highfalutin kind of elevated judicial language is that they're adhering to stare decisis. That's what they're saying at the beginning of Planned Parenthood v. Casey. So this idea of stare decisis, which I said is like making a copy of a copy of a copy. And if you get one bad judicial decision, then the jurisprudence that emanates from that decision is going to be bad. And you're going to get all of these really monstrosities of justice that come down the line. Now, what Sandra Day O'Connor did was she cloaked the court's failure to walk back Roe in this idea of stare decisis, which is, again, it's very stupid to bind yourself in this system to decisions that you know were wrong. And that's
the shorthand is she said, she literally almost said it just this way. Yes, we know that the age of viability of fetuses has dropped because of technology. We now know through ultrasound machines that it's basic, it is murder. But we have to stick with what we said earlier, or else we'll look really dumb. It's 19 years later. We don't want to look dumb.
Right. We don't want to reverse ourselves, because if we reverse ourselves, then people are going to lose faith in the Supreme Court as an institution.
So that was
asinine, because we're losing faith.
Okay, go read it. Go read it.
Yeah.
That's literally what she says.
So the meaning of jurisprudence cannot be it takes no refuge in doubt is that we don't want to look bad, otherwise the whole law system will crumble.
Right, but what makes a judicial system look bad is upholding this murderous regime of abortion, where mothers are free to have their kids murdered and sucked out of the womb with impunity. That's what makes the court look bad. But these people on the Supreme Court, they're off in la la land. You know, they're little mini kings and queens, and they don't think like that. So they're talking about the regality of their institution. And even you get this with John Roberts and Obamacare. One of the reasons he didn't take basically say that strike down Obamacare as being unconstitutional is he said that we should leave that to the political process. We don't want people to lose faith in the courts, because if they lose faith in the courts, then where are we? So we want them to go to the ballot box. And that's really the Roberts doctrine, is we want them to resolve problems at the ballot box, not through the courts. But I'm losing faith in the courts if the courts are feckless and unwilling to uphold the United States Constitution against congressional power grabs. But so go ahead.
Oh, yeah, I just want to bring it to today. We're coming up in an hour. I want to take some questions, about 10, 15 minutes. So do we have enough? So if Amy Barrett or some other Trump appointee.
It's Amy Barrett. They're all reporting it now.
Yeah, yeah. So Amy Barrett gets appointed. Do we have enough to overturn Roe versus Wade, restore the republic? Is this enough? What do you think? Tim?
Well, it depends. Kavanaugh and Gorsuch have essentially, in my mind, switched places. We thought Kavanaugh was the think and Gorsuch was a Hardy, and they look in the last two SCOTUS hearing seasons to have swapped places. Kavanaugh looks like he's willing to go to bat, and Gorsuch has copped out. So by my view, when we're talking who are the real ballers here that are where we can count to 5 on any reversals, whether it's a Kelo versus City of New London reversal, Roe and Planned Parenthood reversal, any of the important property contracts reversals that we need to see come through the courts. We got Silent Sam Alito, who's a baller. Justice Thomas, of course, is a baller. We have Kavanaugh seeming good. You don't want to count your chickens before they hatch, so that's 3. Everyone swears by ACB. I don't know, so let's, for the sake of argument, say she's good. Gorsuch looks like he might be a fink, right? And Roberts is a cuck. I mean, he's the ultimate. And then the other ones are Satanists, right? The other whatever. The other 2 remaining justices are just Satanists. So the Obama appointees. So I think not. I think we're going to need another one. I don't think that I don't know. We'll hear from Dave in a second, but I don't think that Gorsuch has the cojones to do the big time baby reversal of Roe versus Wade, even if ACB does. And I don't really know one way or the other. So it might not be that momentous.
Dave?
Yeah. And again, the question is just, do we think that this is going to be...
it's going to be enough to overturn with Amy Barrett?
No, I don't believe it is. It could be. So this is a vital fight, right? We need to fight tooth and nail to get her on the court, no matter what, because it could be. But if I had to bet my life on this, no, I don't think so, because this is the lifeblood of the left. The culture of death begins and ends with the family. It begins and ends truly with contraception and abortion. And abortion is really contraception on steroids, at least the contraceptive mentality on steroids, but with the added sin of murder. Karl Marx said that no revolution is possible without the feminine ferment. In order to destroy the fabric of the society, in order to remake a society as BLM, Antifa, and ultimately the Democrats want, because BLM and Antifa are the Bolsheviks, the Democrats are the Mensheviks. BLM and Antifa want to destroy the country and remake it exogenously from the outside. The Democrats want to destroy and remake the country endogenously from the inside. And that's very much like the split between the Bolsheviks and the Mensheviks in the 1917 revolution. Of course, true Marxists say that they label, like the Mensheviks, those who want to reform their way to a socialist system. They call them reformists, and they kind of use this pejorative and look down on them. But either way, you have 2 sides that want to gut America and make it into a socialist society, something that it's not meant to be. The only way to do that is to destroy the family, which is why Marx and Lenin were so keen on getting mothers into the workplace. And this is why you see the popes like Leo the 13th and Pius XI writing things like Arcanum and Casti Connubii. One of the first things that the Marxists did when they had power in the Soviet Union was usher in no-fault divorce, because it would separate women from this patriarchal society that is the family. So to rip apart a society, to have any kind of leftist revolution, you need to destroy the family. And you do that first by going to women. One of the main tools to get women out of the house and to gut the family is abortion, contraception and abortion, because women have a nesting instinct. If you don't want that nesting instinct to take root, they can't have children. If women have children, then they're going to want to stay home and be with their children. And hence you get the traditional family with the man breadwinner and the woman who's staying at home and caring for the family. So the left has everything at stake with abortion and contraception, but especially abortion. They cannot, they will not let abortion laws be walked back lightly. They have the regime they want right now, which is why right after the 60s and 70s, when you had abortion and contraception, Griswold v. Connecticut and Roe v. Wade come into play, you see this rapid destruction of society, this rapid devolution of society. It came right on the heels of these decisions, these landmark decisions. So when the left is going to come after us with everything they've got, and they don't play fair. We all know that, right? They show up at your doorstep. They showed up at Tucker Carlson's house. They're showing up at Mitch McConnell's house. They're saying, if we can't sleep, then you can't either. They're going to be out in front of your house with bullhorns. They're going to be threatening you. You know, I've gotten threats. I get them all the time. You get DMs threatening you if you are a conservative pundit or somebody who says anything that's really against the prevailing evil status quo. and they will lean on you. They use all of their muscle, and they don't fight fair. They're bugs. They will attack you. They will threaten you. They will threaten your family. And I've gotten that as well. And that's going to be on steroids when the abortion, the satanic, the child sacrificial jurisprudence is on the line. So even if we get a good justice on, you have to understand that in this world, this side of Eden, in the post-lapsarian world, good is weak. It's really weak, and evil is staunch and dauntless. And so often we see good capitulating in the face of the machinations of the left and the machinations of the diabolical, because they will threaten your livelihood. You have to be absolutely committed to principle if you're going to stand strong in the face of the marauding left. And I just don't see, unless you have like 6 or 5 just absolutely stalwart men of God on the Supreme Court, that they're going to take the stance, because they're really laying out. I mean, you see people shooting up congressional baseball games, shooting up the Republicans that are just out, what was that, 2 years ago?
Right.
Because they're Republicans just playing it like the softball game there. That is the left. They're violent, they're evil, they're anarchists. They want to burn down our cities. You see it with BLM and Antifa right now, and they don't fight fair. So right. I don't see it. I'm nervous about it.
Yeah, this is the reality that people don't think about, is the death threats and the violence and all these little things that are going on behind the scenes to these individuals.
And the court has said that worked, by the way. There have been interviews with justices who've come out and said, well, we like to say that we cloak everything in just pure law, and it's kind of analytical reasoning, just winning the day, but it's not. And we've had justices admit that the protests actually do have the ability to sway them, which is why you see people picketing in front of the Supreme Court when you have these giant decisions coming down. Sorry, I just want to throw it out.
Yeah. How much money was changing hands with all these different decisions behind the scenes? Who knows what? But with it is, like you said, it is a victory. Whether it works or not, it's something we need to take, and we need to fight tooth and nail for that. Dave, can you talk about, you did a video at on the Rules for Retrogrades channel about some of the mechanics of what's going to happen next. Trump officially appoints Barrett. There's some 30, 40 days to the election. What happens next? Can the Republicans actually confirm her? Sure.
Yeah. Okay. So you have to know the breakdown of the seat counts in the Senate, first of all. So for all of you that, just sit around, go home from work at night and like turn on the evening news and like eat popcorn and like that's your entertainment. Most people don't know the breakdown of the Senate. But right now it's 53 Republican senators to 47 either Democrats or independents that caucus with the Democrats. So Democrats for all intents and purposes. So in order to get a justice confirmed, you need 51 votes in the Senate, essentially. And there used to be something called the filibuster, where it was just an old Senate rule. It's not like in the Constitution or anything like that, where the minority party, if they could muster up a certain amount of people, they could make a speech, essentially an endless speech on the floor of the Senate. And that would stop debate from going forward on the actual substantive issue. And the rule was that you had to have 60 votes to break the filibuster. Now, in the Gorsuch election, the Republicans set the filibuster number at 51 instead of 60, because the Democrats were going to all kinds of mischief and really abusing this filibuster power. So now we need 51 votes to stop a filibuster. And there's 50 there's 53 Republican senators, and you have also, as the president of the Senate, the vice president. So in the event of a tie, you have Mike Pence, who can come in and really break the tie as president of the Senate. That's one of the vice president's duties. So what we need is 51 votes to break the filibuster. And that means we can lose 3 Republicans, since Pence is the vice president and he's going to, caucus with the Republicans. So we can lose 3 of them without being able to not break a Democrat filibuster and get the nominee, which looks like it's going to be What's her name? It's eluding me.
Barrett. Yeah.
Barrett. Confirmed. So we can lose 3. Now, 2 have already come out and said, 2 senators, which is Murkowski of Alaska. Thanks, Alaska, for keeping her in, by the way. And Collins that's Maine, I believe. So have said that they do not favor going forward with a confirmation in an election year, and that they are not going to vote to overcome a filibuster or to confirm the nominee in this year. Now, that position, because you have to remember, the Republican leadership has a ton of power in terms of funds for future reelection campaigns, to really lean on a member of their own party and get them across the goal. So now that position has begun to weaken in the last couple of days. Now, I think it was Murkowski said she's going to have to re-look at her stance on that, because, McConnell was really raking her over the coals, probably privately, to get her to come along. So we can lose 2. It looks like we might lose 2. And Romney, he's another weak link. You have to worry about the spineless, feckless, weak link, virtue signaling Republicans, of which there are surprisingly many. But Romney's another main one. He said he will vote to, overcome the filibuster, and so that we can get a nominee confirmed. He will vote on the confirmation. So it looks like we are going to be able to get this nominee confirmed. Now, there's one major danger, though. One thing that, and I pray to God that the Trump administration has thought this through. If there's a hiccup, if this nominee, Barrett, has anything that can be dredged up from the past, the Democrats are going to lean on that. And if it's sufficient and disqualifying, and Trump loses the election, Biden will get he will get to nominate somebody, and we will not get the next Supreme Court nomination. It will be the Democrats that get to put the next person on the bench. There is no room for error here. I pray to God that they have vetted Barrett, and there is no skeleton in the closet. You get one shot at this. And during these times when so much is at stake, when the culture of death is literally teetering on the brink, possibly, the diabolical is absolutely on the Democrat side. It's running rampant. It's putting all of the pressure on Republicans, and it's going to be bringing to the forefront anything that could be disqualifying. We have one shot here. So if anything comes up, we are in deep, deep trouble. It better come up right away. If any Trump people are listening now, if Barrett were to listen to this, get out. Take yourself out of the nomination process. Step back if you think there's anything that could disqualify you for the good of yourself and the good of the country.
Thanks, Dave. Tim, what are your thoughts? Do you think this is going to get confirmed? What do you see going forward? And then we'll get some questions.
Yes, it'll be confirmed. Mitt said he'll go, and we can go down to 50. So we're looking at 51. Murkowski and Collins will be out. So we'll go forward. The main concern is ACB, who we've been told she is for really 3 years. I hope so.
You don't think, Tim, there's any chance that something comes up in the process, like a Kavanaugh situation, where a skeleton or an ostensible skeleton comes out of the closet?
You never know. I don't think so, though. I think that's maybe the foremost consideration of Trump's identitarianism. I'm a big Trump booster. He's dabbled in the identitarianism here, I think, with his pick. I was watching the Florida rally the other night, and he said, kind of virtue signaling, who wants a man on the court? And no one said yes. Then he said, who wants a woman? Everyone knows it's ACB. We're told she's good. I hope she's good. But her foremost virtue is that it's really hard to, for George Soros to organize a campaign of a bunch of men coming out saying that she raped them. I think that's her foremost virtue.
Right. It does seem to be, the skeletons are a little bit harder to produce in that case. So I want to take a few questions, but before I do, one thing that Dave said in his video that I thought was great was the importance of becoming active in the political process as much as possible, identifying whoever is being weak on it and calling them. And Dave or Tim, are either of you going to have more stuff on particular action items when the need arises?
In what particular regard? Just across the board?
Just in terms of this process, the process that we're going through in the next 40 days to confirm this individual. Are you going to have any particular guidance as to what to do or who to call, that type of thing for the viewers, to put pressure on them to confirm and go forward with it?
Write your Congress people always. I mean, the stuff that you've heard a million times as a citizen of a republic, do it. But that's a longer term solution. People haven't done it. People refuse to do it. That's been shown in our republic. People are flaccid and generally speaking lazy. I mean, sorry to be prophetic there, but at this point, no, we're in the late stages of the game. Even if you applied heavy pressure, which you should still do and probably won't do out there, people listening, at this point, it's going to come down to the Senate. The longer term solution is slower going. Right now, we're in the late stages of the game. If you want to make that broad turn with the Titanic, you got to start the turn way earlier. Writing your senator, if you got a bad senator that's a secret Murkowski or a secret Collins that's going to stab us in the back in the late stages of the game, it means they've been paid off, they've been threatened, they've been call that John Roberts. Remember, two nights before the Obamacare decision, when he was paid a visit and he flipped course 2 nights before. If we got one of those 51 good or at least semi-solid senators that's willing to sell out and stab a bunch of babies in the back and stab the Republican in the back, a letter writing campaign ain't going to do anything. So it's in God's hands at this point. We can do is pray. And then starting the next 4 years, assuming Trump wins another 4 years, get politically active, like learn about the stuff we're talking about, write your Congress people, know who your Congress people are, what district you're in. At this point, it's a fait accompli, man. And I get out and vote, make sure that happens in 38 days. But no, the Senate, this is in the Senate's hands.
Excellent. So James De Niro is going back to something you said earlier on in the show, talking about moving. He says, does Tim really think people should exercise their right to move? Doesn't that significantly mess up the social fabric? So this is when Tim was talking about federalism, and if one state does something wrong on the local level, then people can always leave. So doesn't that mess up the social fabric of their lives? Isn't that savage? Says James De Niro. What do you think, Tim?
Well, you tell me, man. I mean, what? I got the hell out of California, dude. Like, what do you want? I just moved to Mississippi. This was the game plan for a long time. If I ever got doxxed, which I did, or fired, which I did, or some sort of physical attack, which, God be blessed, that didn't happen. We were always going to come here to a little shelter in Mississippi, and it works out. It's real, it's practical. It requires a little bit of planning ahead, but yes, it's if we mean that the several states of the 54 of experimentation, then we absolutely should be, as an insinuative principle, prepared to pack up our crap and go.
Here's a related question to the breakdown of the family. Whoever wants to jump in on this, it says median wage hasn't risen since 1970 or so. Isn't that as much to blame for the breakdown of the family as anything else?
No, actually, the median wage hasn't risen since 1970 because women started coming into the workforce. And when you have now an abundance of workers who are willing to work for a given wage, then employers can keep a wage stagnant. So actually, doubling the size of the workforce for employers to draw upon has been a significant factor in artificially depressing wages. Before, if you're scrambling, and you'll see this in engineering companies, because there's not that many Americans that are going to school to become engineers. They're all picking easy majors so they can be like underwater basket weavers or whatever, or DJs. If you have a very limited supply of qualified applicants, then you have to pay them more to attract top talent. To attract talent, you need to give them perquisites. You have to give them nice benefits, because if there's a limited number of people, you want the best people working for you. If you double the size of the workforce, then you have a bunch of people who are clamoring for jobs, who are willing to accept anything, because there's a bunch of people that are now unemployed. So you know what's better than being unemployed? Working for crappy pay and crappy benefits. So it's actually stagnated wages to artificially invite women into the workforce so that they can have an unnecessary glamour career, and then tell their friends that they have a career and they're really empowered, and sit around until they're 42 years old and their ovaries are shriveled and dried up, and then have 1.7 children, and just, you know, the normal American life now.
But look, that's a Marxist socialist argument used by the Bolsheviks. So that's not what is accountable on any Christian basis for the collapse of the family. It's no-fault divorce, all the substantive due process creatures becoming popular in the culture, and people buying what the leftists in government were selling. That's the collapse of the family. It's a moral question. It's not a crass economic question.
Well, also, just to jump on that though, it's so funny. You hear about people in like the Great Depression, when you didn't have all these women in the workforce, and they would have like 9 kids and they all sleep in one room, and they made it through that just fine. People are talking about this like 1955 standard of post-war living, and they're like, oh my gosh, we won't be able to have 2 minivans in the driveway.
Right.
The children are going to starve, so I need to farm my wife out to work and then farm my kids out to daycare so that some, you know, nurse ratchet can raise up my kids, and, you know, my wife can come home tired and groggy and cook us saltless chicken for dinner, which takes 22 minutes, instead of like having a nice meal as a family and having communion. You know, communion and meals go hand in hand. So there's also that. Our idea of like what the proper standard of living is asinine now. It's just, oh yeah, I need a 2-story house and a boat. Otherwise, what am I going to do? I have to have my kids not have a mother teaching them in the home, because we need that boat. So it's a silly argument. And actually, Elizabeth Warren, in her book, The Two Income Trap, details how having 2 parents, this is Democrat, hardcore senator, like quasi-Marxist, Warren, saying that, yes, having 2 women or having 2 workers enter the workforce, the mommy and the daddy, has actually kept the standard of living lower because it's driven up inflation. Now, she proposes more government benefits to answer that, because, of course, the sacred cow of women working and feminism, those aren't to be questioned. She wants more government involvement to answer the problems that are caused by the 2-income trap.
Right on. There's one more question about Barrett, coming from James Marone. A lot of Catholics, Republicans, and conservatives are wanting Barrett, but she also approved of Dems in Illinois having blanket authority due to COVID 1984. This troubles me. Do you guys know anything about the COVID 1984 record of Barrett?
No.
Anything?
I don't. Sorry.
You're
not going to like every decision that a jurist stands for, unless you're talking about someone like a Ted Cruz, who should have been Ted Cruz would have been. Look at Ted Cruz. If you look at him talk in the Senate, you'd think he's like a robot or something. He's built for the court. He's got a perfectly constitutional mind. I believe Ted Cruz could have been the greatest jurist since the founding generation. Could have been better than Nino Scalia. He's built for it. We're passing him up because of the identitarianism somewhat. Maybe it's to hasten the nomination and the ratification. So be it, whatever. So you take it as you get it. When you play the identity politics, you take it as you get it. And I think she's pretty good for an identity politics world that Trump has deigned to dabble in. So
I just can't believe we're here, though, where we can say, you know what, I'm going to take somebody on the basis of sex. I thought that was invidious discrimination. That's what I've been told my whole life, right? So this appointment really violates Title VII of the 1964 Civil Rights Act, right? Because you can't choose somebody for a job on the basis of religion, national origin, sex. You can't do it, right? We're told that is a federally prohibited thing. I don't believe we're at the point when you can openly do this. It's the institutionalization of the bogeyman class. You are allowed to discriminate against straight white males with impunity, and you can do it to a roaring applause of all the peons. You can't do it. If Barrett turns out to be bad, We need to hold everybody that was involved in this accountable. We've had like 2 chances in our lifetime to get Roe v. Wade overturned. And you had it with Reagan, and you have it now with Trump. Reagan screwed us. He put O'Connor on the bench. He wanted to play identity politics, which, as we point out in Rules for Retrogrades, you can't wield identity politics as a conservative. It's like the Ring of Sauron. It only answers to its master. It's disordered from the start, and therefore no good guy can wield it because it's disordered.
Well,
So,
to be fair, though, everyone says she's better. Her FedSoc ratings through the roof. I believe in FedSoc. You know, it's still closely allied with FedSoc. Everyone's saying yes. So then if we overstate it and we say there's no way that you can ever use the ring of power being identity politics, we'll look down. I'm just saying the best guy for the job was Ted Cruz, even better than Mike Lee of Utah, who's pretty good. Ted Cruz is he's got a jurisprudence mind, and he was, even before I knew that Ginsburg was sick for like the 20th time or whatever, like 4 days before she died, I added my buddy Michael Knowles, and I was like, you're now homies with Ted Cruz. Get him psyched up. Let's get him going should RBG die, which she did. It's a shame in a way, but on the other hand, she might be really good, and everyone's swearing by her. So yeah, it's a done deal now. She's there. Let's just don't cop out. Now she better feel that onus, feel that even mechanistic pressure, not just the downward pressure of the leftist mob. Feel the upward pressure. We're going to hold her accountable. Because, I mean, Gorsuch has already screwed us too. So it's going to take another nomination, I think.
This is combat. It really is combat. We need a broad-shouldered person who is going to be able to stand up to the savage assault of the left that is coming. I am telling you, when the abortion case comes up, if it's granted cert by the Supreme Court in a year and a half, 2 years, there is going to be an assault the likes of which none of you have ever seen before. And you need somebody who is going to be undaunted by the savage assault. And generally, obviously, that's a male. The soldier capacity is a male capacity. I would have liked to have seen Cruz. He also would have flown through the Senate because he's an actual senator. And it's traditionally in American politics actually easier to confirm somebody who's homies, who's friends with all of the legislative body that's confirming him. So, yeah, he would have flown through, but whatever.
I'm not convinced he would have flown through, but given the new nature of the day, I think that's one thing that if you're playing identitarianism, I think it's going to be really hard for them to make any of this sex stuff stick. But he's already getting investigated 2 years ago for sex stuff. The left was starting to throw up a cloud. So you just don't know. I mean, at the end of the day, particularly traditional Catholics are inclined toward this bias. They want certain answers. Conservatives, we do too. At the end of the day, there aren't certain answers, and you just have to tell whoever gets in there, you're a soldier now. You're a centurion. You got to fight.
Yeah, go ahead.
I was just going to add, you had asked earlier, and I didn't kind of proffer an answer yet on the what can we do? And I think it actually is important. And like I said, the Supreme Court has admitted that it's moved by picketing, but we know that shutting down Congress's phones actually does move them. Now, with the stakes this high, you're not assured that leadership is not going to be able to kind of ward off any attack we give. But I say if you shut down the phones of the moderate Republicans, you just flood them with calls and calls and calls, because this is what the left is doing. Be sure as I'm alive. Once the candidate, once the nominee is officially given, if it's Barrett, then so be it. Once that nominee is officially announced, the left is going to start flooding the phone lines of the Senate. They're going to start hitting them with letter writing campaigns. They're going to start using economic coercion. They're going to start getting their buddies to lean on them. You need to show support, and that's another rule for retrogrades, is to circle the wagons. You got to show support to the people in Congress. I mean, you also have to have fangs. You need to say, Murkowski, I swear by everything that I own that if you try and hold up this nominee, if you don't give a vote and you don't vote with the party line, I'm going to use all of my resources and my humanly power to make sure that you are out on your butt after this election. Because although she has no principles, she's a soulless harpy. We know that. Although she has no principles, what soulless harpies do like is power. She doesn't want to lose her Senate seat. When she lost the Republican primary in Alaska, what, 7, 8, 9 years ago? And she actually wrote in, she was a write-in candidate as an independent, and she was able to cling to that power because I guess there are enough liberals voted for her to get her to be able to retain her Senate seat. That being the case, you can lean on them and say, you are going to be thrown out of your office if you take this vote, if you vote against the party interests. So we do have that kind of sword to wield.
Excellent. Yeah. Well, on that note, let's pray in Our Father. Pray that if Barrett is confirmed in, she may be filled with the spirit of the Virgin Most Powerful, that she can have mother bear power to stand up against the onslaught of the savagery that she's about to face, that she can see in the aborted children, her own children, and have the type of motherhood power that can stand in the face of the insane chaos that's about to throw at her. So let me get my icon up. Let's offer Our Father. Thank you so much for coming on, Gordon's. Everybody can take a look at Gordon's stuff. I got both their websites at the notes below. Take a look at everything they're doing. So thank you for all your good work for the church. Tim and Dave, thanks for coming on the show.
Thanks for having us.
Thanks so much.
All right, let's pray. In the name of the Father, the Son, the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven.
Give us this day our daily bread, and forgive us our trespasses as we forgive those who trespass against us, and lead us not in temptation, but deliver us from evil. Amen.
In the name of the Father, the Son, the Holy Ghost. Amen.
Amen.